Hi, this is John Linneball of John Linneball Tutoring, and this is AP US History Video 61, After the End of Reconstruction. I'm with John Linneball Tutoring, as I said. My phone number is 415-623-4251 if you want to call me or text me. And my email is john@johnlinneball.com. And my website is www.johnlinneball.com. You can also reach me at johnlinneballtutoring.com. It'll take you to the same site either way. Sharecropping replaces slavery. While the Civil War ended slavery, white plantation owners' control over the arable land in the South meant that sharecropping was the system that would come into place. It was a system by which former slaves could be exploited in roughly the same way that they were when they were actually slaves. Basically, black sharecroppers, that is, former slaves, and sharecroppers of other races who couldn't afford their own land had to pay to rent land using their future crops, which of course were undervalued compared to the prices the landowners would get for their commodities. Even more than just normally, yes, you have to sell things for more than what you bought them to make a profit. This was pretty exploitative. So basically, the result was the same as slavery. So you can think about that song, you dig 16 tons and what do you get? Another year older and deeper in debt, then goes like St. Peter, I can't go, can't go off to heaven because he owes his soul to the company store. That basically they charge more money than they know that he's going to be able to make. So hey, the store comes from the company, they know how much he makes, and they just charge a little bit more. So how about that? He's always in debt and has to keep working there. All right. Understandably, most African Americans were agricultural workers immediately after the Civil War. Plantation owners hired groups of African Americans who were usually supervised by white overseers to perform farm labor. Naturally, the African Americans weren't happy to be offered essentially slavery under a different name when at least some Republicans had promised them their 40 acres and a mule. You can see APUSH, American U.S. History 60 video APUSH 60. Okay, we've got that straight. Now, however, this proposal made by the radical Republicans, remember, the Republicans of that era were not like the Republicans of this era at all. Anyway, that simply never passed Congress, the whole 40 acres and a mule thing. So let's move on. Da, da, da. If you look at the Wikipedia article on sharecropping, you can learn a lot about what the South was like right after the Civil War and for a considerable amount of time afterwards, and actually in other regions in the US. After the Civil War, Southern landowners had large land holdings but practically no cash to pay the laborers. And of course, the former slaves, who are now called freedmen, owned no land or other assets. So, of course, they had to work to support their families, probably on somebody else's land since they didn't own any land. So, the result, well, they came up with a sharecropping system based mostly on cotton, which was the main cash crop of the antebellum South, and other crops as need be or as demand insisted, demand demanded, ha ha ha. Anyway, the large plantations were subdivided into plots that could be worked by sharecroppers. Initially, the sharecroppers in the American South were almost all black former slaves, but later on, poor white farmers were integrated into the system. During Reconstruction, the Federal Freedmen's Bureau ordered the arrangements for freedom and wrote and enforced their contracts. American sharecroppers worked a section of the plantation independently, usually growing cotton, tobacco, rice, sugar, and other cash crops, and received half the parcel's output. Sharecroppers also often received their farm tools and all their other goods from the landowner. So remember what I said about the company store? Okay, the former plantation owner, hey, now he runs the company store. So the landowners dictated decisions as to the crop mix, what crops would be grown and in what proportions. And sharecroppers were subject to agreements to sell their portion of the crop back to the landowner, often at unfair prices, since they couldn't negotiate with other purchasers. Maybe other landowners might say, hey, I'd like to buy some of that fine cotton you've got there. And the landowner would say, it's mine. Okay. Furthermore, landowners could pressure tenants into accepting unfair prices by threatening to refuse to renew the lease after the crops were harvested. So, sharecropping was usually extremely unfair to farmers as the landowners held massive economic control. Sharecropping continued to be a significant institution in many states for decades following the Civil War. By the early 1930s, there were 5.5 million white tenant farmers, sharecroppers, and mixed croppers/laborers in the United States, and 3 million similarly situated blacks. In 1930s Tennessee, roughly one-third of the farms were run by sharecroppers. Two-thirds of the sharecroppers were white. In Mississippi, by 1900, 36% of all white farmers and 85% of all black farmers were tenants or sharecroppers. In 1910, Georgia, African Americans owned fewer than 16,000 farms, but at the same time, African Americans were tenants on 106,738 farms. Around this time, sharecroppers began to form unions protesting mistreatment, beginning in Alabama in 1933 and Arkansas in 1934. The Southern Tenant Farmers Union, which included both blacks and poor whites, used meetings, protests, and labor strikes to demand better treatment. These actions succeeded well enough to make landlords afraid and angry, leading to retaliation by the landlords. Sharecroppers who fought the sharecropper rental farming system were vilified, harassed legally and illegally, and physically attacked by officials, landlords, agents, and sometimes by rioters. Strikes by sharecroppers in Arkansas and Missouri, including the 1939 Missouri Sharecroppers Strike, were documented in the newsreel "Oh Freedom After a While." The plight of the sharecropper was addressed in a song by Charlie Barnett and his orchestra. Is a song called Sharecropper's Blues. Da, da, da. Hey, Sharecropper's Blues. Okay, we're going to move on to the next slide. The sharecropping system in the U.S. increased during the Great Depression because many farmers became tenants following the failure of their small farms during the Dust Bowl. Traditional sharecropping declined after mechanized farm work became economical in the 1930s and 1940s. As a result, many sharecroppers had to leave the farms and seek factory work in cities or become migrant workers in the western United States during World War II. By the end of the 1960s, sharecropping had disappeared in the United States. Approximately two-thirds of sharecroppers were white, the rest were black. Sharecroppers, the poorest of the poor, organized for better conditions. The Southern Tenant Farmers Union, as we mentioned before, represented sharecroppers of all races and made gains for sharecroppers in the 1930s. Sharecropping did decrease because of several factors, including the Great Depression and farm mechanization. Reconstruction. Getting back to Reconstruction right after the Civil War. Well, Reconstruction changed the Constitution. The constitutional changes, amendments, were based on new ideas about American identity and social goals. These new ideas caused debates regarding rights for African Americans, women, and others. So, the Reconstruction era constitutional amendments were the 14th and 15th amendments. Of course, the 13th Amendment banned slavery, but these moved further than that. The 14th and 15th Amendments to the Constitution gave citizenship to African Americans, so not just freedom, but citizenship, equal protection under the laws, and the franchise, which means the right to vote. No, I didn't say French fries, ha ha ha, the franchise. So, franchise means vote. Unfortunately, these rights were limited by violence, at least officially illegal violence. It was violence that was certainly tolerated, even though it was officially illegal, and political tricks, which, as always, are usually perfectly legal. But the 14th and 15th Amendments would become the main support for 20th century civil rights precedents, such as Brown versus Board of Education, the famous U.S. Supreme Court case that banned separate but equal public services accommodations, etc. So let's move on. Unfortunately, the Dobbs decision on abortion appears to be the first step in undoing these precedents. Let's take a look at Wikipedia. Dobbs versus Jackson's Women's Health Organization, citation from 2022, is a landmark decision of the U.S. Supreme Court in which the court held the Constitution of the United States does not confer the right to an abortion. The court's decision overruled both Roe versus Wade, which is the landmark case that made abortion legal in the first place, and Planned Parenthood versus Casey, which returned to individual states the power to regulate any aspect of abortion not protected by federal law. And Justice Clarence Thomas argued the court should go further in future cases, reconsidering other past Supreme Court cases that granted rights based on substantive due process, such as Griswold versus Connecticut, the right to contraception, Obergefell versus Hodges, the right to same-sex marriage, and Lawrence versus Texas, which banned laws against private sexual acts. He wrote, because any substantive due process decision is demonstrably erroneous, we have the duty to correct the error established in these precedents. So that's what Clarence Thomas wants. So you might be asking, what is substantive due process? Well, you could go look it up in Wikipedia, and I'll put that in the description below, a link to that Wikipedia article. Substantive due process is the idea, the legal idea, that some unenumerated, that is, things that aren't specifically listed in the Constitution, are simply beyond the reach of state and federal laws because they are fundamental rights that should never be left to the will or the whim of the majority. You can't have the majority just beat on minority members for no particular reason. Legally I'm speaking, but you shouldn't do it physically either. So these rights include women's rights, LGBT plus rights, rights of racial minorities, rights of religious minorities, etc. Clarence Thomas has essentially decided substantive due process isn't a valid principle of constitutional law. Now, that's a little odd, considering he's a black man married to a white woman. This is Justice Thomas, and this is his wife, Virginia, also known as Ginny Thomas. And Loving versus Virginia. Hey, isn't that funny? Her first name is Virginia, and it's a case involving the state of Virginia. Okay, obviously a coincidence, but I have a weird sense of humor. So anyway, Loving versus Virginia is at least partially based on the idea of substantive due process, so I don't know. Anyway, when I first read about the Dobbs case and Justice Thomas's opinion, I did think of this one. Seriously, Your Honor, just get a divorce if you're sick of Ginny. I could just see Ginny Thomas being, What the hell, Clarence? You wrote this whole decision just to make it so we can't get married? What's wrong with you? Ha ha ha. But anyway, don't know why somebody on the Supreme Court would want to vote against his own self-interest and against his own civil rights, but there you have it. And if you want to know more about Ginny Thomas, she's an interesting character. You can see Ginny Thomas, the Ginny Thomas entry in Wikipedia. All right, let's move on. Segregation laws in the South were known as Jim Crow laws. The term's name may have come from a popular dance show called Jump Jim Crow that featured white actors in blackface making fun of blacks. Later in the 19th century, Jim Crow became just a general demeaning term for blacks in general. Jim Crow laws segregated restrooms, drinking fountains, railroad cars, and the like. They also generally made blacks second-class citizens. Jim Crow laws first appeared in 1881. Now, for those of you who are from north of the Mason-Dixon line, don't get too hoity-toity. Jim Crow existed in different forms in the North. For example, until they couldn't have them anymore, so probably in the 1960s, there actually were sundown towns, that is, towns where blacks were officially, by law, not allowed to be in these towns after sundown. One of them is the town I grew up in, which is basically so far north, if you go much further, you are actually in Canada, but definitely they had a rule that unofficially said, let the, hey, black person, don't let the sun set on you here. Wasn't usually put in those terms, but it did exist, and it really did exist in my hometown. I didn't believe it when my mother told me, and then I found out later, no, she was actually right. Anyway, if you want to know more about that, you can go to Wikipedia and look up Sundown Town. Look at the Sundown Town entry. All right, let's move on. The Supreme Court limits the 14th Amendment. The U.S. Supreme Court officially approved of segregation in the South, circumventing the 14th and 15th Amendments using a states' rights argument, I should say. And if you want to know more about that, you can go to my previous video, APUSH 60. The slaughterhouse cases from 1873 was a consolidation of separate lawsuits. That's why they're called the cases, not the slaughterhouse case, brought by New Orleans slaughterhouses claiming state governments violated their 14th Amendment rights. Slaughterhouses claimed they had been shut down without any due process. Now, this wasn't a civil rights case, but a commercial case, but same idea. They said, hey, wait a minute, 14th Amendment says we get due process of law no matter what it is, doesn't have to be civil rights. The U.S. Supreme Court held the 14th Amendment didn't apply to state rights, and that would be any rights that weren't primarily based on federal rights or new federal law, but things that were based in state law and general principles of state law that existed for a long time. So the plaintiffs had 14th Amendment rights for things that had been created by the Constitution, for example, the right to interstate travel or the right to vote in federal elections, but not anything dealing with commercial activity that was generally left to the state. So that'd be in the same state, commercial activity, health regulations, state elections, etc. While the slaughterhouse cases didn't directly address civil rights, it was obvious that many civil rights were concerned with state, local, etc. laws, not just federal laws. The logical extension of the slaughterhouse cases to civil rights was the holding in Plessy versus Ferguson from 1892, in which the U.S. Supreme Court found segregated train cars were not prohibited as long as the accommodations were separate but equal. This holding was not overruled until the Supreme Court ruling in Brown versus Board of Education from 1954, in which segregated public schools were found to be illegal based on the plain language of the 14th Amendment, that no state was to deny any person equal protection as promised in the 14th Amendment. African Americans are left out of politics. Legal actions limited African American participation in politics, denying them the same rights most white citizens had. Poll taxes and literacy tests often kept poor, or in quotes, illiterate blacks who couldn't answer questions that many white voters also wouldn't be able to answer if they had to, from voting, but poor, illiterate whites could be, in quotes, grandfathered in. The idea was based on a grandfather clause in the law where men could vote if their ancestors, that is, their fathers or grandfathers, had been eligible voters before the Civil War. If you want to know more about that, you can see the Wikipedia article on the grandfather clause. And here's a few things. Take a look at this literacy test. They ask some things that I would say many U.S. citizens would not be able to answer. For example, presidents elected in the general election of November takes office in the following year on what date? Well, I guess a lot of people might know it these days, but you know it's in January. It's not January 6th, but that's also an important date. And there's some other things that, a person appointed to the U.S. Supreme Court is appointed for a time of. A lot of people might not get that right. And these are questions, for example, there's a 1965 Alabama literacy test. Again, you'd have to be pretty good at American history to really know this American history, American government, or somebody who's really up on things. The literacy test, there's a lot of things they could just give somebody something that's really hard to understand. I know someone told me sometimes they would give someone a newspaper that's not written in English and say, oh, gee, you can't tell what that is. Well, I guess you're not literate. All right, so let's move on. Today, the term grandfather clause usually just means a situation where the government or some private agency will continue to apply an old standard, that is a rule, to people who already qualified for that status back when the old standard still applied, while applying a new standard or a new rule to people who hadn't qualified for the old rule while it was still in effect. So, for example, people of legal drinking age in some states, when the drinking age was under 21, were still legally permitted to drink when all states raised the drinking age to 21. That didn't happen in all states. For example, New York State raised their drinking age a couple of times before it became 21. And so people who could drink at age 18, all of a sudden, nope, it's 19. Then people who could drink between 19 and 21, when the age went up to 21, oh, nope, you still have to wait till you're 21, even though you could legally drink for a little while. You can also see things from private groups like the Mensa IQ group. That's a group that uses IQ tests to determine who is in the top 2% as far as IQ scores go, and those are the only people who are eligible to be part of Mensa. And they still do actually. They will use SAT scores from, I think, about 1978 up till about 1978. So, be basically the 1970s or before. They could use that as evidence that your IQ test is in the highest 2%, but they won't use modern SATs. I don't think modern SATs are that much different, but they just said, okay, since we let people do that up till, the late 70s, we'll let anybody who actually took one of those tests do it, because otherwise it would be unfair to these newly admitted people who want to use the same test that we used to let everyone use. African Americans are left out of politics. Democratic primaries limited participation to only whites. So in other words, only white voters could be part of the Democratic primaries. Why is that a problem? Well, besides being obnoxious and just keeping someone out of a major political party, you could say, well, why does that matter? Couldn't they have their own party? Well, the trouble is the only other major party was the Republican Party, just like today. And Republicans in the South practically never won, so the primaries were the only meaningful elections. whites-only primaries were essentially whites-only general elections. The Ku Klux Klan and the KKK was founded in 1866. And of course, that's the organization that we know was a terrorist organization that lynched blacks and white opponents of the segregated South. Local law enforcement, sheriffs, etc., didn't do anything because, well, they didn't have to, and probably many of them either were members of the KKK or associated with people who were in the KKK. So they did nothing to stop lynchings, and because of cases like Plessy versus Ferguson and these slaughterhouse cases and the way that certain presidential elections were resolved, basically Reconstruction ended and became much weaker than it had been before. So the federal officials couldn't do anything, and the state and local officials simply weren't going to do anything. Second Reconstruction. Brown versus Board of Education was part of a second Reconstruction in the 20th century based on the first Reconstruction. Basically, civil rights activists never stopped working to complete the work done during the first Reconstruction. What do I mean? Well, for example, Supreme Court cases, U.S. Supreme Court cases, don't just come out of nowhere. Generally speaking, they are appeals of things that happened in the circuit courts of appeal, which themselves are the results of appeals from trial courts, federal trial courts. So, and of course, the original trial doesn't happen unless somebody actually creates a case or controversy that the trial court has to resolve. So how do you get that? Well, you protest. You do things that are illegal and you defend it on the grounds that this shouldn't be illegal. I have the right to do this. This law is illegal and should be struck down. Sometimes state laws can be struck down if they conflict with the federal Constitution. That's another way the U.S. Supreme Court might get involved. Anyway, that's something that led to an awful lot of reform starting in the 20th century, and of course most famously in the case of Brown versus Board of Education. Now, here's something that's going on today. It does relate to the Reconstruction era amendments to the Constitution. So, for example, this year, actually this month, November 2023, when I'm recording this, the Eighth Circuit Court of Appeals ruled that Article 2 of the Voting Rights Act of 1965 doesn't allow lawsuits by private citizens to enforce laws against race and other kinds of discrimination in voting. The holding of this Eighth Circuit case was that only the U.S. Attorney General can actually bring a lawsuit based on discrimination in voting. So this should look familiar, especially if you've watched the previous video, number 60, and you watched this video up to here, that this is kind of the counterpart to the states' rights argument that was used to support Jim Crow laws. It's part of a 1-2 punch combination. So as Reconstruction waned, they put in things like this. So, well, you can't sue states in federal court using federal laws when the laws are about rights that are traditionally left to the states, because those are states' rights. So therefore, that has to be handled by the state attorney general, has to be handled by state courts, etc. And hey, if the state attorney general, who's generally going to be the office or the officer that is legally entitled to enforce these laws or fail to enforce these laws, gee, that's too bad if they choose not to do anything. So that's not good. All right, the private right of enforcement, which allows non-government plaintiffs and non-government lawyers to file suit, has been vital in the enforcement of civil rights laws. Why? Well, basically, state and federal attorney general's office only have so much money and so much time and are only going to take on so many. But John Q. Public or Jane Q. Public and the attorneys who represent them, they have a lot of time to file cases that busy federal or state or local attorney, government attorney's office may not have time, or they may be disincentivized for some reason, like, geez, I'm not going to sue that guy, he's my friend, that kind of thing. So, as democracydocket.com says, and don't worry, I'll have a link in the description below, and you can see the link here too. It says, well, now today's ruling, only the U.S. Attorney General, who brings relatively few election-related cases this year, would be able to bring Section 2 claims in the 7 states in the 8th Circuit: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. So these are pretty important Midwestern states, and some of them are actually pretty populous, like Minnesota, for example. So that affects a lot of people. And you can even see the link to the 8th Circuit opinion. I will put that below in the description, and you can read this all for yourself. And there's also a Washington Post article that discusses this at length. It's pretty good for a mainstream newspaper, but there is a paywall, so you'll get to watch or read it, I should say, maybe once or twice before they tell you, you've got to subscribe to watch this. But the Democracy Docket one is one you can look at all you want. So go look at that. So what the 8th Circuit is basically saying is, even if it is about a federal right created by the Constitution, only the U.S. Attorney General is allowed to sue for it. If they won't do anything, that's too bad. The Washington Post and Democracy Docket both note in their decision, the 8th Circuit judges noted that in the past 40 years, at least 182 successful Section 2 cases have been filed. These are about voting. And of those, only 15 were brought solely by the Attorney General. So whenever, in all those other cases, either the Attorney General was not involved, or they had a lot of help from private attorneys and private citizens. By my logic, the 8th Circuit just conceded the point made by the NAACP that private action is necessary to enforce voting rights in many cases. The 8th Circuit ruling is basically like refusing to allow a chronically under-policed neighborhood to hire its own private security. And yes, this really does happen in cities where they either can't or won't pay for appropriate police coverage, but where they do have wealthy neighborhoods that would not like to be chronically victimized. Does that make sense, to not allow those people to find another responsible way to defend themselves? That is putting in kind of a quasi-police security firm rather than just saying, oh, I know, we'll just go out and put up vigilantes with guns, or we'll just have people walking around with whatever they want to use and doing whatever they feel they have to do. That's a bad idea. So private attorneys, you can think of them as kind of the private security that might supplement a police department in an underfunded neighborhood, in an underfunded city. And, well, I guess it wouldn't be an underfunded neighborhood. It would be a pretty well-funded neighborhood in a city where generally the police are underfunded. And in my opinion, private attorneys probably cause less damage than private security firms, but both of them are A-okay with me. I'm just trying to make a point here, so let's move on. The U.S. Department of Justice was against the 8th Circuit's decision in that case. They argued for private enforcement, and the 5th, 6th, and 11th Circuits have all upheld the private right that the 8th Circuit panel overturned in a 2-1 ruling, and a Trump-appointed judge is the one who wrote that 8th Circuit decision. This decision, or a similar one, will probably end up in the Supreme Court, which may result in the court going Back to the Future. I don't know if you've seen any of those movies, but basically, yeah, they might shoot back to a time that I think was in Back to the Future 3, where they go back to cowboy days in the 1880s, which seems oddly appropriate here. So they would actually return to a time when Jim Crow laws could be enforced anywhere that states passed them. Did you find this video useful? If you did, please like it and subscribe to my channel. Neither action costs you anything. You'll be alerted about my new videos. Why do I care? Well, it's simple. YouTube doesn't let me share any ad revenue unless I have 1,000 subscribers and 4,000 hours, that's 240,000 minutes, of view time in a year. While I do have more than 1,000 people watching these, or at least subscribed, I don't have 4,000 hours of watch time. For the same reason, you are not only welcome, but encouraged to share links to this video, put it in playlists, etc. I'm always happy to read and respond to constructive criticism or suggestions for new videos. I do reserve the right to delete comments from and block those who specialize in destructive criticism, trolls, or things that are off topic, spammers, disturbed people, people who just chronically don't get the point. Anyway, but on a more positive note, thanks a lot for watching. This is not a substitute for your classes, text, etc. This video is based on Barron's AP US History Review book, 4th edition, any online sources to which I have referred in this video and that you'll see in the description below, and my general knowledge of US history. While this should help you do well on your AP US History exam, I can't be responsible for what your teacher thinks is important and asks you in his, her, non-binaries, own tests, homework, etc. Please read your class texts and pay attention to what your teacher says in class. All right. And finally, contact me. You can reach me at john@johnlinnebaugh.com. You can see my website at johnlinnebaugh.com. And feel free to call or text me at 415-623-4251 or call me at 415-986-7355 and leave a message. This content is also available at testpreparation.locals.com and LBRY, sort of short for library.com, as well as facebook.com/Linnebaugh tutoring. Thanks for watching.